To get started, I'm first of all going to ask Mr. Howard Libel, who's chairman of the reception committee, to introduce any of our guests that we have present. And sometimes instead of introducing a speaker, it's well to introduce an audience to the speaker. I think any speaker likes to know who he has in his audience. So I'll ask Mr. Libel to introduce the guests and to also find out how many undergraduates as well as how many graduate students we have here tonight.
Well, first of all, we're honored to have the Jay County prosecutor, Mr. and Mrs. John Ressler, there on your left. They are currently involved in 2 libel suits, so they have an interest here. They might be liable or libel. Then also we have a past professor of Ball State who was teaching here for 24 years. He's been retired for 17 years, Mr. Lawrence Hurst, who simply could not turn down the invitation to hear Mr. Engelhardt speak. So with no further ado, may I turn it back over to Mr. James Wick.
I think, as you noticed from the invitation, we will be following this by a discussion hour in the regular journalism classroom. I think that's room 214, and Mrs. Jean Houston is in charge of the refreshments this evening. We thank her for being the chairman of the refreshment committee, and there is certainly plenty of coffee for everybody. And so we'll retire at the close of the lecture tonight to the regular classroom and follow that with a brief discussion period. And we especially invite our guests, both of the undergraduate group as well as the graduate students, to stay with us after we have recessed. We considered this of sufficient importance tonight that the physical plant department has sent in a public address system, and we're grateful to them for looking after that detail. Also, audio-visual aids presumably are recording this. It was to be recorded, at least recording equipment was requisitioned for this, and it will be on file in teacher material service for any future reference, for any of you who want to use it in your teaching or for any other purpose. Some who may have missed this tonight that will want to know more about the subject content will have that available through teacher material service after tonight. Now, in regard to the address, the committee approached Dr. Engelhardt in regard to his subject, and he very frankly said that he would talk on Indiana birds in their native habitat. But the committee reconsidered because they figured he didn't know any more about that than I did about articulation when he called on me a week ago. So we have prevailed on him instead to speak on how liable for libel. And I think that from the indication of the interest here tonight, it is a timely subject, because also in Mr. Ribel's county of Shelby County, there's also a defamation suit now going on against the newspaper there that has been brought by the sheriff of that county. So these are matters of some timeliness to all of us, and we now present Mr. Journalism himself, Dr. Louis Engelhardt.
I'm overwhelmed, apprehensive. If you hear the counselor from Portland chuckle once in a while, you'll know that maybe I've wandered astray and probably don't know what I'm talking about. But in case that isn't so, maybe you might like to ask questions. Well, fortunately, he is here, and he'll be glad to answer some questions. I hope that that's so. Of course, part of the problem with this is that I've been more or less forced to prepare for this evening instead of providing one of these lectures by inspiration, for which I'm infamous. I suppose the best way to start a discussion of this sort is with an introduction of a type, because it's impossible to discuss libel and defamation without having some perspective of where this business fits in the scheme of things in the country. So I have prepared a 20-page introduction to introduce my 2 or 3 pages of notes. I suppose the best place to start is perhaps with the provisions for free speech that you find in the United States Constitution and in 50 state constitutions. There is a philosophical base that led to the formation of this provision, allied to the nature of the kind of government that we have in the United States. This philosophical base assumes some things or holds some things as a priori assumptions. First of all, it believes that an individual citizen is a free agent within society, and it guarantees a vast number of freedoms or rights to that individual citizen because he is a free agent. The first and right that is clearly available is the freedom to think. Now, this right is absolute. No one can restrain or restrict freedom in any fashion. His freedom to speak and promulgate his ideas via the press or otherwise is nearly absolute. It's nearly absolute as a practical freedom or right can be. But his freedom to take specific actions based on his beliefs really isn't absolute. It's clearly restricted by government in various ways. But government cannot completely control such action. Most of the constitutional and statutory and common law activities that exist place restraints upon the government and others in their ability to limit the freedoms of the individual, his actions as well as his thoughts and his freedom to express his thoughts. The role of government largely becomes that of protecting an individual's status as a free agent in his person, in his physical well-being, and in his possessions. For government to do its job, it must have a body of law specifying how to proceed. Citizens then are to use and abide by that law. Citizens are also to respect and accept other citizens on an equal basis and regard highly the individual freedoms and rights guaranteed by constitutional and statutory law, whether federal or state. These rights are outlined primarily in the United States Constitution in its Bill of Rights section and in subsequent amendments, and refined and reiterated by virtually every state constitution. We've listed as many as 50 such rights that can be found in these documents. Now, all of these documents accord the greatest emphasis to freedom of thought, freedom of expression, freedom of the press, and the press includes printed and electronic media. Now, government and society can be effective and wholesome, and the lives of individual citizens can be happiest if wisdom and respect are used in the continuous development of the body of the law and in all public policy. Citizens thus should have the raw stuff of wisdom at their disposal. This includes facts, thoughtfulness, opinions, a free and vigorous exchange of these, freedom to challenge, reject, accept, or change these, and freedom and opportunity to read and listen. Now, certainly a strong educational system should contribute ultimately to the strength of wisdom in the nation. And certainly opportunity to speak and write and print and broadcast widely and freely should contribute to the strength of wisdom. As a matter of fact, it's far better that stupid, shocking, false, selfish, and devious things be thought, said, and printed than that they not be. Else how would anybody have a frame of reference to use in deciding what is stupid or sensible, shocking or realistic, false or valid, selfish or unselfish, devious or straight? Decisions about such matters are opinions, of course, and it is doubtful that great agreement among persons will automatically occur. Thus, there no doubt will be clashes of opinion and debate on all matters. This contentiousness is wonderful, because it gives society its dynamic quality and its motivation to seek change and improvement. A free society wherein citizens have full opportunity to think freely and have full access to information and public debate through a variety of media has a prospect of a brighter future. Belief in and dedication to such a concept is paramount to the American definition of the democratic method in our Republican form of government. To assure freedom of thought, speech, and press, there are several things expressly forbidden or expressly allowed. First, the law does not require persons always to tell the truth. The law does not require that persons know what they are talking about. The law does not require that persons believe what they say, read, or hear. The law is not concerned with the motives a person may have in his thoughts or expression thereof. Freedom to think, speak, or publish is a right of an individual citizen, not the right of a newspaper, except insofar as the newspaper is a corporate extension of an individual or individuals. The press means any extensive distribution of material by mechanical, graphic, or electronic means. Certainly it includes duplicated materials, mimeographed materials, printed materials, pamphlets, books, tracts, magazines, newspapers, journals, billboards, radio, television, motion pictures, and others. Since some of these are quite inexpensive, anyone can exercise his freedom to publish readily. No prior censorship to determine the suitability from any standpoint of material prior to publication is allowed, condoned, or provided for by any governmental agency. In other words, virtually anything goes. And philosophically, this is good. But you might say, can't the unrestricted and uncontrolled freedom of the press destroy some of the other rights so dear to people? Should there not be some restraints? Restraints, of course, could come from governmental control, or from laws enforced by court injunctive action, or from self-appointed vigilante pressure groups, or from the ethical maturity of professional commitment to a journalistic media. You might say, well, how could the press abuse the other rights that people might have? Well, now some people say it could harm and dismay people by publishing obscene, pornographic, and prurient stuff. Vigilantes have attempted to restrain publication of such and its distribution in a variety of means. Now, they always fail. Laws have been tried by cities and states, but these invariably are declared unconstitutional. Really, no one quite knows what is obscene. To some, almost everything is. To others, nothing is. The courts side with the latter. Remember, obscene and disgusting are not synonymous. Besides, there is one school of psychological thought which contends easy availability of obscenity and even hardcore pornography is wholesome in terms of mental health and the forestalling of deviant behavior, since it constitutes a pleasant and harmless sublimation or substitute for violence. Now, if you don't know what to think of this, consider the court, which must decide on the basis of law questions of this nature. The court finally says something like this. Would denying this material access to the public prints withhold a modicum of the raw stuff needed for wisdom? The answer is usually yes, it would. So the court normally says it's not really obscene. This is the record of almost all courts, not just the Supreme Court. Now, are there other areas of concern? It is true that society holds that an individual has a right to a personal and professional reputation and is entitled to the respect and sufferance of his fellow citizens in his exercise of his personal, public, and professional life. Anything that is said or written about a person that holds him up to public hatred, contempt, ridicule, or scorn in these areas would certainly weaken, if not destroy, them. From this concept has grown a body of statutory law operating in the area of defamation. Now, under some rather rare circumstances, an act of defamation can be considered a criminal offense. But these circumstances could not apply to the press operating as a press. Defamation can be done two ways. If defamation is an oral presentation, by law it is considered to be slander. Very few slander actions are pursued in court because normally their extent is indeed limited, and the chimerical nature of oral communication is such that it is difficult to prove even that what a person thought was said or implied was actually said or intended, even with witnesses. Visual defamation, on the other hand, can be seen over and over and re-examined easily by a court. Most defamation actions are for libel or visual defamation. Visual defamation would apply certainly to newspapers, books, magazines, and so forth. It also applies to letters, photographs, works of art, statues. It also applies to movies and even to radio and television, since the court holds these media to be merely presenters of mouthings of prepared scripts. To a court, no such a thing as an unrehearsed, unexpected, uncontrolled ad lib remark exists. Well, now let's get something straight right now. No law prohibits a publication or utterance of a defamatory statement. No agency is empowered to police out or censor such statements before or after their initial publication. A person defaming another person in a newspaper has not committed a crime. It is highly proper, ethical, desirable, beneficial, moral, and correct that a newspaper or other agency on occasion deliberately and viciously seeks to libel and defame someone with the hope of utterly destroying that person's professional and personal life. The weight of the laws pertaining to libel is to determine if a specific act of defamation is thus justified or if it was unjustified. Now, adverse criticism, severe or mild, is not defamatory and in no way constitutes grounds for a libel suit. No government agency reads the papers to discover possible libel and then seeks court action. I bet there's many a prosecuting attorney who's glad that that's not part of his job. The only way a court can consider the justifiability of a libel comes when and if a person who has been libeled and believes he is suffering damage as a result enters a civil suit seeking recompense for such damage. If he doesn't sue, nothing happens. If he does sue, he may or may not win that suit. Generally, it will be difficult for him to win, since usually a newspaper knows what it is doing, and since the laws pertaining to libel are designed to protect the newspaper as much as the plaintiff. This is the nature of a civil court tort, or the nature of laws of equity which govern civil court actions. Well, let's take a closer look at just what can be considered defamatory or libelous. Courts say that an article is defamatory if it, 1, holds a person up to public hatred, ridicule, or contempt. 2, imputes a lack of competency or qualifications essential to the proper conduct of his trade, office, profession, or calling. 3, imputes criminality, dishonesty, moral delinquency, dishonorable or disgraceful conduct. 4, imputations which make a person ridiculous in the eyes of his fellows, or which are calculated to affect him adversely in his trade, office, profession, or calling. 5, imputations of insanity, mental incompetence, family irresponsibility, infection by a loathsome social disease, unchastity of a woman, lewdness or sexual aberration, And 6, reporting a living person is dead. Now this list and modifications of it could obviously be quite long. It's easy to see why a person offended by an article in the paper or in any other visual device could assume he was defamed and sue for damages. But it isn't that easy. He must obtain competent legal counsel and enter a civil suit against the defendant. In his charges, he must specify exactly what he considers to be defamatory. Now, his case could even be dismissed before it ever reaches open court. But when it does reach open court, several steps are involved. Usually the first thing that happens is something we call arraignment. Now, arraignment actually means simply that the court announces the next case that it's going to consider. After arraignment, the defendant is called and identified. Now, before he says a word, motions can be made to drop the case. They can be argued and ruled upon by the court. If the judge rules favorably on a motion, the case may be dropped then. Indeed, similar motions can be introduced at any time, so the case can be concluded with no finding whatsoever. After the ceremony of opening the case, the court must do 3 things in defamation or libel actions. First, it must determine whether the defendant's statement, the newspaper being sued that is, actually was libelous. The statement could be called libelous because of the actual words themselves. This is called libel per se. Or it could be libel per code, which means that within the context of the statement, it is libelous. Now, if the statement cannot clearly be determined to be libelous, thus, no defamation as such occurred. The next question for the court is to determine whether or not the statement was actually communicated. It doesn't seem to me this would be very hard to decide in the case of a newspaper. Some other things might be a little less clear. Now, the third thing that the court does is probably the most important thing usually, because in it the court must determine if the defendant had a legally justifiable reason to publish a libel. There are several reasons that justify the publication of defamation. Now, if the defendant, the newspaper being sued that is, tells the court that he had a justifiable reason, then the burden of proof falls upon his shoulders rather than upon the plaintiff or the person suing the paper. The newspaper, the defendant then must establish the validity of such a defense to the court and its jury's satisfaction if a jury is involved. Sometimes they are, sometimes they aren't. Now this, of course, might take some doing. At any rate, here are the legally acceptable justifications for the commission of libel. First, the thing printed was true. Truth plus good motives. If the material presented can be established as being true, and that the defendant had good motives in publishing such truth, no court in the nation will award civil libel damages to a plaintiff. Good motives doesn't mean super-duper, gold-plated, heaven-ordained, and mighty good motives. Really, it means doing the job a newspaper normally does, and that there is no malice in fact present. Indiana happens to be one of several states wherein truth alone is considered an adequate legal defense against a libel action. You don't have to talk about malice in fact or good motives or anything in Indiana. Now, if your defense is that the material is true, then you must prove that it's true. It should be relatively simple and possible to prove the truth of factual information. But it is virtually impossible to prove the truth of an opinion. So you better stay away from the truth as a defense when the material is largely opinion. You turn to a second classic defense called fair comment and criticism. Now, the law holds that anything a person offers to the public can be evaluated and criticized by members of the public. Authors, artists, musicians, entertainers, actors, and many other persons obviously make their livings with offerings to the public, and amateurs even get into the act. Now, you and I can criticize such offerings severely and viciously. Now, furthermore, we do not need to know anything at all about the offering or the medium of its presentation. As a person, we can like it or dislike it, and say so in no uncertain terms. The word fair in this defense, in no way means sweet or gentle. It means simply that you restrict your comments to the public offering and do not stray into other aspects of the artist's life not related to the public offering. Since we can form opinions about many things, it seems to me that fair comment and criticism would be a most useful defense. Among other things that have been held fair game for such criticism are preaching, politicking, coaching, and teaching. Most people are essentially private citizens, but there are some hardier souls who become public figures by virtue of their vocational and public life. These persons virtually surrender all they love, all they have, to the public. So it is possible to comment and criticize about everything about them, including their family and financial status. Indeed, public entertainers frequently build the myth of sexual prowess and promiscuous vigor to intrigue the public. So even their genitals are in the public purview and can be discussed freely to the point of ridicule. There's one classic example of a fair comment and criticism case that no one can speak about this unless they bring up the Cherry Sisters case. There was a vaudeville troupe performing in Iowa some years ago, and they sued a newspaper, the Des Moines Register, for an article that they published. They picked up a statement from the Audible Iowa Chronicle that a little reporter by the name of Billy Hamilton had written about the Cherry Sisters. And the Cherry Sisters said this virtually ruined their vaudeville career. Well, I wouldn't be surprised what it might have, but you can't help but read this without chuckling a bit. And this is a classic one that everybody brings up. Here's what the Des Moines Register published. Billy Hamilton of the Audible Chronicle gave the Cherry Sisters the following graphic write-up of their late appearance in his town. Here's what Billy said. Effie is an old jade of 50 summers, Jessie a frisky filly of 40, and Addie, the flower of the family, a capering monstrosity of 35. Their long, skinny arms, equipped with talons at the extremities, swung mechanically and anon, waved frantically at the suffering audience. The mouths of their rancid features opened like caverns, and sounds like the wailings of damned souls issued therefrom. They pranced around the stage with a motion that suggested a cross between the dance de ventre and the foxtrot. Strange creatures with painted faces and hideous mane. Effie is spavined, Addie is stringhalt, and Jessie, the only one who showed her stockings, had legs with calves as classic in their outlines as the curves of a broom handle. These people lost the suit. The courts held that Billy was perfectly proper in criticizing them that way. Now, really, if someone sues for something like this, for this kind of comment, they really would be laughed out of the court, since their public station automatically requires them to become the subject of all sorts of conjecture and curiosity and comment. Now, among public figures, in addition to dancers and people like that, are teachers and preachers, and the politicians. Now, a politician will say almost anything, and anyone can say almost anything about a politician with never the slightest worry about libel action. This has always been true. When a politician threatens to sue an opponent for libel, he is only grandstanding. Part of the reason the politician has no chance of winning a libel suit is that his voluntary choice to enter politics was a public proclamation to have at him. Now, there are some other reasons, tied up with a series of recent Supreme Court decisions. In the fair comment and criticism of a private or semi-private citizen, the court demands that any statement of fact be true. But in the case of a public figure, the law no longer asks or even suggests that truth be required or involved in anything said. As a matter of fact, you can even lie a lot and not be liable for libel action when you're going after a public figure. So the public figure virtually has no protection of any kind against defamation of any kind. The court holds this as exactly what he deserves. But wait a minute. Recently, the court has held that every private citizen also functions in some phases of his life as a public man. This public man role opens that part of his life to severe and sardonic criticism, just as the entire life of the public figure is fair game. In effect, this means almost anyone can be attacked and defamed in the public prints and have little recourse in libel action. So libel laws now are indeed heavily weighted in favor of the newspaper or the libeler. So don't be afraid to speak up or write it. Now, actually, this is not a new concept. It's really been in effect for generations. So for generations, public figures haven't bothered to sue for libel, except as a publicity stunt. Instead, they choose to reply in kind. Now, this reply in kind, this mudslinging, this name-calling, certainly makes for vigorous and unbelievable campaigns by politicians or hilarious entertainment by others. Truly, it still is possible to libel a public figure, but hard to accomplish. Now, another area of defense stems from something we call privilege. Some public officials, when they're functioning in their role in a circumstance of public record, enjoy an absolute privilege to say whatever they wish, and under no circumstance can they be liable or sued for such utterances. Especially happy to use such privilege are ambitious members of Congress. Absolute privilege pertains to certain criminal proceedings, civil court proceedings, city councils, and other things too. Now, a reporter can enjoy a reflected or qualified privilege of such proceedings so long as his report of them is accurate in fact and a reasonably fair representation of what happened. This certainly is a strong defense and should be relatively easy to establish if it's applicable in a defamation suit. Now, in addition to these rather standard defenses, it might be possible to enter these factors as mitigating circumstances in the trial. Here are some things that sometimes are said. One, of course, is reply in kind. If the plaintiff has actually replied in kind and carried his case thus to the public, the court probably will throw it out. He's had his vindication or his turn at bat. Second, if you say, well, we repeated a statement that was made by someone else or some other agency, we repeated it in good faith and with no opportunity to reason to question its validity. Now, you do that sometimes. But you know, when you say that, it's pretty dangerous. Because who knows whether you're telling the truth anyhow, and if you are, it indicates you're pretty stupid, doesn't it? If you're a newspaper person, you're supposed to check things out. Here's a third one you might say. We made an innocent mistake, typographically or otherwise. Well, now, for crying out loud, learn to proofread, copy read, and double check your news facts. Fourth, we have printed a retraction. Now be sure this retraction is freely and generously given. Don't wait to be asked or forced. Give it reasonably prominent display, and don't make it more vicious than the original libel. A good retraction might influence a court some. Fifth, maybe you should apologize as well as retract. Now here's one that sometimes comes up. New Hampshire, I think they do this a lot. Point out that your report was in keeping with the common talk and evaluation of the person that had existed in the community for years. This is about the worst gamble of all you can take. Be very cautious with this one, certainly. Seventh, have the liable person sign an agreement not to sue before he has a chance to file suit. Oh my, you have to be in trouble in court if you try to bamboozle someone with such a worthless extra legal agreement. Such stuff really has no status of any kind in any court. Now all of these merely are mitigating circumstances. It cannot really be used as a legal excuse for defamation. They might have the effect of convincing the court to reduce damage payments somewhat, but if you use them unwisely, try to bluff with them or something like that, they could convince the court to heap on punitive damages too. Now, if the court decides that the defendant has injured the plaintiff with unjustifiable defamation, the court will order the defendant to pay the plaintiff these damages, these kinds of damages. First, maybe merely nominal damages, wherein the plaintiff is really seeking exoneration rather than money. Second, actual compensatory damages for money lost by the plaintiff because of the libel. Now this amount is relatively easy to ascertain and is usually rather modest. Third, general compensatory damages for such things as mental suffering and anguish, loss of faith. When you get into this area, the damages can start getting bigger. But the really big money is in punitive damages, which are assessed to punish a defendant clearly guilty of defamation accompanied with malice in fact. Oh, by the way, if you lose this case, there will also be court costs for you and the plaintiff that you'll have to pay. Now, maybe you'd like to know who all can be held accountable for libel. Actually, anyone connected with the initiation, writing, processing, editing, printing, and distribution or broadcast of the libel can be sued. This means everyone from the newsboy to the publisher. It means that if there's libel in an ad, all you can be sued. If there's libel in a letter to the editor, you can all be sued. But practically, the only persons who are sued usually are the initiator and the writer and the owner of the paper. The writer is sued to prove that what he wrote was not true. And the owner is sued for money, since he's usually the person that has the money. Now, in case of libel in the Ball State News, who could be sued? Technically, all of us. But actually, hardly any of us. Yes, the student who wrote the libel could be sued, and the editor perhaps could be sued, and the state of Indiana could be sued, and an advertiser could be sued if the libel was in his ad. Now, don't get the notion that the state of Indiana cannot be sued, because that isn't true, and don't think that because you're under 21 that you could escape prosecution, because that isn't so either. Now, here's the thing that you'd discover, that the advisor to the Ball State News probably could not be sued. President Emmons could not be sued. The citizens of Indiana could not be sued. The board members, the Board of Trustees could not be sued as individuals. The involvement of any people, any of these people, would be only as fiscal agents of the state and not as individuals. I doubt if they could even be considered that in our case, since we have written statements provided by the Chief Finance Officer indicating that the university cannot legally and will not be held responsible for any financial liabilities of Ball State News. Now, if he's mistaken, if he doesn't know what he's talking about, then Ball State University would be financially responsible. But if he's correct in his statements, the suit would end probably with the editor. Well, now, let me say this. Really, most knowledgeable people do not consider libel laws to have one iota of restraint on the freedom of the press. Other laws pertaining likewise to the press have little consequence on the basic freedom of the press. Now, I've ignored such bodies of law as invasion of privacy, which stems from common law, really, copyright, advertising regulations, and similar legal considerations from this discussion. Instead, our subject has been libel, so I've tried to stay to that. But maybe I ought to give you some advice before I go too far. Here's some advice that's frequently given. Now, if you have been defamed or libeled in a newspaper, should you sue? Should you enter a suit? First of all, I'll say certainly not, unless you have a good lawyer and you are willing to listen to him. I would go on and say it's doubtful that you should sue, since your chance of winning are rather negligible in most cases. Secondly, no, because win or lose, you place on record the damaging facts which can be paraded with impunity thereafter, repeated over and over by everybody else. Third, no, it'd be better to play, you can use one of these rules, say, do a little role playing, you know. Say, oh, I'm above the rotten level of the writer and cannot be touched by such scum. Take that pose. Or, say, I'm a good sport and accept the defamation as part of the game. Or be magnanimous and forgive the writer for his transgressions. Or you can sob, or you can laugh, or you could throw yourself on the mercy of the public and promise to straighten out your awful life. Another kind of advice given would be no. Instead, reply in kind. Hit back hard, since a civil libel trial would take months to show up on a court docket. By then, the election might be over. Fifth, no. Instead, demand a retraction and an apology. Sixth, yes, go ahead and sue, but hope to settle out of court. 7, yes, but hope to get publicity only and not to win. 8, yes, and seek heavy damages, since truly you have been grievously and unjustifiably defamed. 9, no. Instead, buy the paper and fire the staff. 10, no. Start a rival paper and really raise hell with your detractors. 11, no. Issue statements to rival media refuting the libel. 12, no. Buy advertising space and time, some in the offending media even, to use to set the record straight. 13, yes, go ahead and sue just for the fun of it. Now, if a newspaper has unjustifiably libeled someone, defamed someone, it should do these things. First, it should apologize immediately, sincerely, and in person to the person. Second, it should ask his permission to publish a retraction. Third, the paper should admit freely and frankly and publicly any and all errors of fact or judgment you have committed at all times, not just in this case, but if you make mistakes, admit it. Don't beat around the bush. Say we were wrong. Fourth, suggest that the liable person agree not to seek further damages by court action. Now be careful, because this is not real protection against a suit, and it might cost you to get such an agreement. This would certainly not be acceptable to most people anyhow. Can't buy people off, you know. Now, if a suit is entered, you might want to try to settle it out of court. Remember, this is if you definitely did libel unjustifiably someone. Sixth, you might seek to mitigate damages by calling mitigating circumstances the court's attention in an honest manner. Seventh, be ready to appeal. Ninth, if the lawyer thinks this makes sense, you could plead nolo contendere, which is a dirty kind of plea that sometimes throws a case in complete consternation. Or eighth, maybe you ought to buy some libel damage insurance. Now, how does a newspaper really go about avoiding libel, getting involved in it to start with? Well, first of all, you probably should retain a lawyer on a continuous basis. Consult with him and pay attention to what he tells you. But here are some other things you could do too. First of all, you should always tell the truth. Just don't lie and you're all right. Second, in order to tell the truth, you do a thoroughly good job of reporting. Third, you adhere to ethical standards of fairness and reasonableness. Fourth, you do not hesitate ever to fight and expose corruption or incompetence in public life. Fifth, it would be a good idea to prepare some sensible guidelines based on the specific state laws in your state for staff members to follow. Sixth, you ought to hire competent staff members. Now, these should be college graduates with adequate college journalism training and adequate training in other subject matter specialization. Seventh, you ought to raise your salary schedule to at least $150 per week for beginners, and then you can demand only competent help thereafter. Eighth, never accuse someone of a criminal act or even imply such a thing unless you are prepared to prefer charges and go into court and prove his guilt. Now, even though newspapers no longer worry about libel as a constant threat from outside, they really consider it the result of internal stupidity. The question remains, should a newspaper deliberately seek to defame someone? Now, the answer should lie in the intrinsic nature of the person's performance measured against the greater good of the readers of the paper. Now, tempered by a commitment to an ethical profession called journalism, which is a necessary and desired function within democracy, a competent professional will be able to answer questions of this nature. There's one other factor which might be helpful to you, would be the strengths and guidance of a statement like this one, which surely we've all read and understand. It goes something like this: be ye kindly affectionate one to the other. Thank you.
Art asked about his honorarium, and I didn't know what to answer him, but I think your applause indicates that you greatly appreciate his presentation. I'm sure that it is certainly worthy of future reference. It's something of which I'm sure all of us know is comprehensive and into which he's put a great deal of hard work. It ought to give all of you a great deal of courage in going into newspaper business or journalism. You should be like the small town editor that said half the city council are idiots, and when they objected and wanted a correction, his correction read, half the city council are not idiots. As far as I know, he never got into any trouble. We live in a society where, as far as I know, anybody can be sued or anybody can sue. As the lawyers sometimes say, you can sue the Bishop of Boston for bastardy, but to prove it on him is something else. I hope that you'll all have a great deal of courage when it comes to your journalistic career. Meet with us for a discussion period now, if you will, in 214, if you can stay, and especially our guests of honor.